seconds to go. Start. Mr. Sibbal, while referring to the definition of money laundering under Section 3 of the PMLA, submitted that the ED must satisfy itself that the proceeds of crime have been projected as untainted property for the registration of an ECIR or the application of the PMLA. It has been vehemently argued that the offence of money laundering requires the proceeds of crime to be mandatorily projected or claimed as untainted property, meaning thereby that Section 3 is applicable only to the generation of proceeds of crime, such proceeds being projected or claimed as untainted property. It is stated that the pertinent condition of and projecting or claiming cannot be ousted and made or interpreted to be or by the explanation that has been brought about by way of the amendment made by Finance Number 2 Act 2019. It has been submitted that such an act would also be unconstitutional as being enlarging the ambit of a principal section by way of adding an explanation. It is also stated that the general practice is that the ED registers an ECIR immediately upon an FIR of a predicate offence being registered. The cause of action being entirely different from the predicate offence as such can lead to a situation where there is no difference between the predicate offence and money laundering. In support of the said argument, reliance was placed on the Article 3 of the Vienna Convention, where words like conversion or transfer of property for the purpose of concealing or disguising the illicit origin of the property or of assisting any person who is involved in the commission of such an offence or offences to evade the legal consequences of his actions have been used. It is asked that what was sought to be criminalized was not the mere acquisition and use of proceeds of crime, but it was the conversion or transfer for the purpose of either concealing or disguising the illicit origin of the property to evade the legal consequences of one's actions. Reference was also made to the preamble of the PMLA, which refers to India's global commitments to combat the menace of money laundering. Learned Counsel has then referred to the definition of money laundering as per the Prevention of Money Laundering Bill 1999 to show how, upon reference to the Select Committee of the Rajya Sabha, certain observations were made and hence the amendment was effected wherein the words and projecting it as untainted property were added to the definition which was finally passed in the form of PMLA. We have reproduced the relevant sections provisions herein below at the appropriate place. Reliance has also been placed on the decision of Tarachand. The safeguard provided by Section 173 of the CRPC, it is argued, was present in the original enactment of 2002. The same has now supposedly been whittled down by various amendments over the years. It has been submitted that by way of amendments in 2009, proviso have been added to sections 5 and 17 which have diluted certain safeguards. Stop.